And we are live. We're live tonight with Drew. Hi, Drew.
Hey, Rich. How are you, bud?
I'm good. And I see your X, just to kind of put it out there, you're at Karma Collects, if anybody wants to stay in touch with you. KRMA Collects, COLLECTS. And JR, hi, good evening.
Hey, I was looking for my joke.
Okay. And yours is what, Widener at Widener 2004?
Yes,
Yeah.
Widener 2004.
WIDNER 2004.
No,
right?
WIDENER 2004.
Oh, okay.
Widener.
Okay, nice. I know it's a common name, and it's possible impossible. Mine is at Not Legal Advice. The only reason I keep on saying that is because my original account got hacked, and because Elon is in DC, his crew can't get my account up and running again. So if you want to follow me at Not Legal Advice with a K, KNOT Legal Advice, one word. We're kind of here, and it's pleasantly, I think it's a pleasant opportunity to hear from an expert in the MMTLP segment. And of course, before we start, and I'm referring to Drew, certainly not either of us, and clearly not legal advice. You know, this is entertainment, hopefully informational, and hopefully it provides some benefit to everybody. Great jokes, of course, not. Before we start, what do you call a cow with only two legs?
I don't know.
Eileen. Did you hear about the guy who lost his job in the blanket factory? Apparently, it folded. And last but not least, did you hear about the guy who went to the seafood yoga class? He pulled a muscle. Anyway. So Drew, you're familiar with MMTLP, is that correct?
Vaguely, yeah.
So how did you get interested in MMTLP and get involved?
So back in November of 22, I have a cousin, and my cousin reached out to me and said, "Hey, I want you to look at these two tickers." And I said, "Okay." And he gave me the tickers, and I never looked at it again. And he called me and he said, I really, did you look into it? I told him I didn't have the time. And he made another call to me, and he really insisted. And, my cousin's going through some stuff. He's got some mobility issues, and, he laid it on a little thick with me. And he was like, "Listen, like, this could be something. And if it's something, it could make a difference in my life." So I said, "All right, fine." I looked into it again. I looked into it this time. I did a little bit of a deep dive on some of the investor presentations that were floating around out there. And I felt comfortable with it. And I also saw...
Is this in 2022?
Yeah. And okay. So he asked me in November 2022. I didn't end up... No, I'm sorry. 21. Yeah, 21. I didn't end up purchasing until January of 2022 because I just didn't look into it. And when I looked into it, I felt comfortable with what I saw with the asset. And of course, you see the spec. And the spec wasn't really a big part of the decision for me, but you have to recognize that it's out there. So I jumped in. I told him, okay, like, I'm going to jump in. And I told him, like, don't go too heavy, but I'm going to jump in too. So I jumped in, and I didn't look at this thing. Like, the price would move, and my cousin would call me, and he would, send me texts about, like, "Oh, this is what's going on." And I'd be like, "Yeah, okay, cool. We'll see what happens." And then we started seeing some significant price movement going on towards the end of the year. And I got interested. The 424 came out. The S1 was approved. The 424 came out. And I was really interested to see what was going to go on in those last couple of days. Because I didn't have so much invested in this that it was the end of the world. So I figured, you know what? I'm going to let this ride, and we're going to see what happens on these last 2 days. And I was excited.
This is now December of 2022?
Yeah. And I remember very clearly waking up on December 9th and opening up my platform and seeing that there's no bid and ask. Like usually there's stacks of these level 2s, but there was nothing there. And that, in my experience, told me that, okay, something happened here at the regulatory level or at the level of the exchange. And sure enough, I saw the corporate action, and that was that. And I saw the daily notice, and that was that. I knew that there was, some action on StockTwits, but I didn't know there was a very large community on Twitter. And this was days after the halt. I think I posted a screenshot of the FTDs, and I said so much for no imbalance. At the very minimum, these FTDs exist. And that tweet got a lot of attention. And I was going through the likes and all of that, and I clicked on someone's name, and there was a purple ring around it. I had no idea what that meant. No clue. This was December 16th or 14th, somewhere in there. And I learned what a Twitter space was on that day. And that's when I got involved. That's when I started to get vocal and involved.
Did you have any suspicion that almost like 3 years later that you'd still be involved and trying to consummate this trade?
I'm sorry, say that again.
Yeah, I mean, did you when this kind of became a problem, December of 2022, did you have any suspicions that it was going to take 3 years and you'd still be at it 3 years down the road?
I thought this would be resolved by just a couple. I thought, you know what? In a couple of weeks, they're going to bring this back. They're going to fix it up. And then I thought by the end of February, they're going to have this resolved. And I was wrong.
Well, if you were going to, yeah, well, you might. No, I think you were right, but they were wrong, and that's why we're here. I think we had Curtis on, and he was talking about one of the issues being able to kind of put the dispute in a simple box so somebody who's not really familiar with it doesn't get lost, because it's a super complicated, a topic. So I kind of asked you before we got started, and I didn't give you a lot of time to prepare for this, but I figured if you were going to kind of describe this in a minute or two to someone who really didn't understand this, how would you describe the MMTLP situation?
In 1 minute?
1 or 2 minutes.
What I would say is that a Series A preferred share was issued to people who owned a stock at the time of the merger. That Series A preferred share was never supposed to be made tradable. 4 months after it was issued, it was made tradable. We still don't know who did it. The regulatory establishment allowed this thing to trade for 14 months. The regulator, the brokers, and even the vice president of the market all informed the investing public that we had until December 12th to close our positions. Broker communications stated the same, and some broker communications even stated that on those last 2 days, all the shorts had to close. Then we woke up on December 9th and discovered that not only was all trading halted, but our assets were effectively stolen from us, frozen from us. And in the last 2 years, we've been fighting for simple and basic transparency that the regulatory establishment that supposedly exists to provide it has refused to provide.
Do you? You've been intimately involved. I know you. I know you were involved in approaching Congress with other people. And I don't know if you've had interactions with FINRA and the SEC, but do you have an opinion of the SEC and FINRA with regard to their performance as it relates to MMTLP?
So there's kind of a lot to unpack there. I've had hundreds of contacts with Congress in different forms: phone calls, emails, Zoom meetings, the gamut. The only thing I think I haven't done is send them Morse code or a telegram.
Let's divide out. Let's keep Congress separate, and then we'll get to Congress. But with just regard to FINRA and the SEC, I don't know if you've had specific contact with them or you cannot talk about it.
I'm happy to talk about it. So FINRA in the beginning was really interesting. On December 14th, I wrote the Securities Exchange Commission and FINRA letters asking them to, look into this, tell us what happened here. Because at that point, we didn't have all of this evidence that we had, and I was still on the fence about the spec because I'm a critical person by nature. So I was writing to them and asking them to look into this thing. And FINRA did something real interesting. They assigned some person who they gave the name Jack Chase to a phone line, and any MMTLP calls were routed to Jack Chase. Jack Chase was very dismissive, in some cases downright rude, was even downright nasty about saying, you're not allowed to record this call. Like, where is the transparency in that? So, like, if you're asking me, how do I feel about the way the regulatory establishment has handled this thing? All I know is that we're not asking for identities. We're at this point, we're not even asking for money. We're asking for simple, fundamental transparency as to the possible existence of phantom shares. And they've refused to provide that to us.
So do you think there's still, as of today, there's still an impediment to a resolution, the regulators?
I know for a fact that they are not being cooperative via any avenue, be it the legal avenues. They've decided to fight things tooth and nail instead of provide basic transparency. And at the congressional level, I do know, especially recently as well, there has been some contacts from Congress to FINRA, and FINRA just points to their FAQ and supplemental FAQ that has been thoroughly disproven. And with respect to FINRA, I'm just going to land my plane on this. FINRA issued a response to a letter that 74 congressional representatives signed. And in their response, they completely evaded the question of who listed the security. And they completely, in my opinion, misrepresented what their role could be in performing a share audit. And I think that those two things are very glaring indicators of how they have performed thus far.
And I remember the documents that I think Howard got from the FOIA requests that were provided suggested that FINRA and the SEC were both pretty cognizant of what was going on in or about the time of the U3 halt.
Oh, you broke up a little bit. What was that now?
Oh, I was saying is that it was pretty obvious from the documents that were obtained from the FOIA request that the SEC and FINRA were cognizant of what was going on at the time in question, and they weren't ignorant of what was going on.
They absolutely knew that there was an issue, but rather than, here's the thing that gets me. Why didn't they intervene in November of 2021 when this popped up on their fraud radar. I know that would have saved me from buying it, but they're talking about after letting this thing trade for 14 months and letting the investing public pour into this thing, they're talking about they did this trade halt to protect the public. It's absolutely, to me, that's an egregious response. And I'm not the only one who feels that way.
Yeah. The two other people on this video also feel that way also. So, yeah, I think it's ridiculous. Their position was always ridiculous. It never made any sense.
So Drew,
go ahead. I'm sorry.
So Drew, I'm going to pose the same question to you that I posed to Curtis, because I genuinely want to know what your opinion is. So, you know, my experience with Congress initially was very positive. You know, I did a tremendous amount of Zoom calls, you know, once we hit that full court push. And, you know, when I went down to DC in December of 23 and we had some pretty upper level meetings, I did not feel as though they were positive. And I felt like it had been ebbing and flowing. So where do you see the congressional push now? Like where do you feel like it's at now? And then what do you attribute to, you know, where you feel it is on that scale?
So a lot to unpack there. I kind of look at the congressional efforts, my involvement in them. I look at it as two phases. Phase one was creating that awareness. And then phase two was everything that occurred after Ralph Norman's letter. Ralph Norman's letter helped us gain a significant amount of awareness. And when you're asking me, how do I feel, you know, about where we stand with Congress right now? Listen, a lot of offices are not as engaged as I would like, but you don't need to get everyone on board. You just need to find the right person who has the right amount of moxie. That's the word I'm going to use. Who has the right amount of moxie and the willingness to take action in furtherance of transparency here. And I am very confident that we have a couple of those relationships. I've actually made, dare I say it, I've become friends with some of these staffers. Some of them, you know, we just emailed each other to wish each other happy holidays when, you know, when the holiday season was going on. But the situation with Congress is something that evolves. And the latest stage of evolution right now with the advent of the Department of Government Efficiency, and more specifically the post that they put out on X stating that they were going to be investigating possible abuses, frauds, and manipulations at the Securities Exchange Commission, that adds kind of a new fold to the mix. And I am finding, you know, I have found, and I know I've spoken to Richie also, who's done some great work with Congress as well. And Richie and I both have gotten commitments from a number of representatives to write letters to the Department of Government Efficiency, asking them to investigate the Securities Exchange Commission's handling of the MMTLP situation, the possible existence of phantom shares, and whether any favoritism towards institutions played a role in the way they handled it. And that's the diplomatic way of saying it.
I have a kind of a broader question, kind of unrelated to MMTLP, but kind of in your dealings with Congress and going through that process, what kind of surprises, or did you have surprises that, you know, that after, you know, before, and then you interacted with these people, and then after that, something occurred to you that was really not what I expected? Anything that kind of jumps out at you?
In a good way or in a bad way?
Either way, maybe one of each. How about one of each?
Yeah. So I don't want to say who, because as much as I would like to put someone on blast, the fact of the matter is, when you're dealing with an organism like Congress, if you go after one, their colleague that you might be trying to make headway with will see that and won't appreciate it. So, but there have been situations where you show them, something that's irrefutable, and you see their reaction, and you can tell that you're striking a chord with them. And then, you come back to them on the follow-up in a couple of weeks and say, what's the status of this? And without giving you a concrete reason, they tell you, oh, we've decided to take a step back until so-and-so, or until this plays out or that plays out. That's been, that's happened, and I'm sure it's going to happen some more. But I've also, like I said, I've done some Zoom meetings with people and sat down and talked to them and just felt like, man, I couldn't get the point across. And those were the representatives, and two of them that come to mind ended up being some of the first reps that sent independent letters to FINRA that helped us plant the seeds to get that Ralph Norman letter effort going. So you never know. You never know who a politician is truly beholden to until you ask them to take an action.
Yeah, that was going to be my next question. Actually, that's interesting. Okay. You went there. I was going to ask. Do you think that any of the Congress people are beholden to other financial interests? I was being very generous in my language there.
I think as a rule of general principle, it would be foolish to say that politicians aren't beholden. Some politicians are not beholden to certain entities.
Okay, fair enough. JR, were you going to say something? I'm sorry, I interrupted you.
Yeah. I got a question. I just lost it. I'm sorry. Okay, so Frank, I'm going to read it just because it's funny. Frank J. It's a legitimate question though. Frank J. In explaining it to a Browns fan and not an Eagles fan, how would you correlate yesterday's and today's filings with relevance to MMTLP holders and not just MMAT holders? So he's genuinely asking, what's the difference? Because MMAT is obviously in bankruptcy, and their current shareholders or shares are, they're going to be classified as Class 6, Class 7 unsecured creditor, but MMTLP holders are not. So I think he's genuinely asking how is the impact of this different for each?
Okay, before we go there, I just wanted to close out the Congress, and then we'll go right there. So my understanding is that congressional efforts are, our efforts are being yours, and whoever's doing it, efforts continue with Congress, and notwithstanding whatever happens in the past, there's a new Congress, so you might have more luck with the new Congress too. We don't know. Yeah, we'll have to see how it plays out. Okay, so now answering the question, do you want to take a shot at it? Do you want to take a shot at it, Drew?
I mean, so specifically the items that were subpoenaed for production yesterday are not just in respect to MMAT. The line under the items to be produced section of the issued subpoena is these requested documents are in respect to metamaterials, MMTLP, or other QSIPs or legend identifiers pertaining to meta or MMTLP. You can't forget that MMTLP was a metamaterials Series A preferred share. And the fact that it was made tradable, usually when a security is made tradable, the company sees some benefit out of that. In this case, the company saw no benefit from that. Metamaterials did not make a dollar, to my knowledge, off of the trading of MMTLP. There was no offering of MMTLP after it was made tradable. And, you know, allegedly what was made tradable was what was already out there. So I think that Metamaterials' position on this is that by MMTLP becoming tradable and the fashion in which is widely believed that MMTLP was manipulated, that caused harm to their shareholders because it was their Series A preferred share. But the short answer to Frank's question is the documents that are being requested are respective to both securities. So I would say it has a tremendous benefit to not only MMAT, but MMTLP shareholders. I don't know shit about football.
Okay. Well, neither does JR. JR, do you have a take on that?
Yeah, the Eagles won the Super Bowl and the Browns aren't very good. I don't disagree with anything Drew says. There's a significant difference between the two. You know, I don't know. I mean, obviously, again, MMAT is the entity in bankruptcy, so their shares are going to be classified as unsecured. They'll be classified as unsecured creditors and find themselves in the lowest priority. I think the big difference is, you know, MMAT, and I'm speculating. This is me speculating. MMAT, the organization, MMAT, the shareholders. You know, if all this plays out to fruition, let's pretend for a second that everything is 110% accurate. There's some level of settlement like there was in Sorrento. All that cash is going to the estate, and then it'll be distributed to creditors and whittle its way down. The positive for MMTLP is the access to the data, you know, which is kind of what we all wanted. So it really is, you know, this wait and see to see what the opposition looks like, to see how long this is going to take. But that's how I see the difference between the two.
Please kind of pick it apart, whatever I say, the next part of whatever I say, please. I'd enjoy it if you please do. So I was looking back, by the way, JR, because JR and we studied Sorrento Therapeutics. So I found June of 2023. I did a couple of videos on Sorrento Therapeutics, and basically the title of the video was Sorrento Therapeutics, Another Solution to Naked Shorts. So at that time, JR and I, because we were talking about this for quite some time, we thought that it was a possibility that we didn't know specifically what entity might use it, but we knew it was a possibility because we knew the judge in Sorrento Therapeutics made the brokers disclose their share count. They didn't have to disclose it to the public, but they had to disclose it to the judge. And by disclosing it to the judge, they admitted to having short positions that shouldn't have existed. And even if it wasn't like the greatest price to cover, they had a cover, and the price was kind of a negotiated price. It wasn't like they got, you know, $1,000 a share, but they didn't get $2 a share either. So it was a process whereby the judge forced the brokers to comply. So, you know, it's funny what we were talking about. So I thought MMAT, to be honest, that was the one that popped in my head. We also thought about NextBridge at the time, but it wasn't something that we felt, me in particular, because JR, I don't think JR was really thinking this way per se. It just occurred to me that if NextBridge was in Chapter 11, a voluntary, not to go out of business, but to kind of reorganize, that they could fit the Sorrento Therapeutics kind of model too. But I really thought about MMAT. So we come down to today with MMAT. The only difference are, you know, there's differences, but the one difference between Sorrento and the MMAT bankruptcy, and I don't know if it's significant, but it's probably a question worth asking to whoever the bankruptcy counsel is and the trustee, is Sorrento Therapeutics was a Chapter 11, and the MMAT is a Chapter 7. I don't know, and I'm not a bankruptcy lawyer, but I don't know if the different classification impacts the rights of the creditors, of the shareholders, and it's something that should be looked into. There is a distinction. Obviously, a 7 is you're going out of business, so long, folks, and 11 is a reorganization, and that you're going to stay in business, hopefully, and pay your creditors over time. So that's one distinction I noted. And again, I think it's something to be looked into, because I wouldn't want the outcome to somehow exclude remedies that might be helpful for MMAT shareholders. Now, when I say MMAT shareholders, I really think the bankruptcy, and this is the way I thought of it, was really an MMTLP bankruptcy, because normally in a bankruptcy, theoretically, you're trying to get assets, you're trying to pay debt, raise cash. In this bankruptcy, the biggest benefit would be the actual information. It's much, in my opinion, that's much more valuable. All the trading information that exists regarding MMTLP, I think that's much more valuable than any assets that you might be able to claw back and sell and generate some money. But I think the proceeding itself, and I know it's in Nevada. I looked at the pleading. It's in Reno, Nevada. The attorneys who are representing the shareholders are extremely experienced attorneys. They should really know their stuff. And I think it's a real possibility if the judge is aggressive and follows the hint of the trustee, because in essence, the trustee is the one who's the person pushing. The trustees in that position. I'm actually involved in a case right now, a bankruptcy case right now, and we have a trustee involved. And depending on the case, the trustees they may benefit from bringing in assets and generating monies beyond their own fees. So there may be a situation, and just another suggestion is and this is what I did with our receiver. So we have a receiver in GTII. Receiver, I think, is in a very similar position to what a trustee is in a bankruptcy in this kind of case. I tried to assist the receiver as much as I could and tried to find out how we could most benefit the receiver. Because I think if you can get aligned with the trustee and the trustee can get aligned with you, then the trustee will push harder and might provide access to greater documents, information, etc. Because with them, it's an issue of cost. They probably have their own law firm. They have to pay. A law firm has to get paid to either pursue litigation or pursue investigations. But I think there's a pretty wide gamut of remedies that are available in a bankruptcy court that wouldn't be available in another court. And so I think there's a great opportunity. Really, I do. And I thought it, and JR and I thought about it, way back. It didn't really come to this till the last management of MMAT did whatever they wanted to do. I don't know if you have any comments, thoughts on any of that, Drew?
So there's also a lot to unpack there. I mean, you gentlemen are attorneys, and you're very well familiar with how the subpoena process usually works. But in bankruptcy court, it's a little bit different. In bankruptcy court, the trustee has the ability to issue these subpoenas, and as long as alluding to what JR said, as long as they are not contested, those subpoenas stand.
Yeah.
And so, the short answer to your question is that defining characteristic of a bankruptcy proceeding vis-a-vis a federal court proceeding, I think makes all the difference for us.
And talking about what you were just referring to, the documents, ultimately the judge can really make it easy, because if the judge decides to require the production of documents from various brokers, it's likely that will cause other things to happen, because they won't necessarily want to disclose certain information. So it's kind of, the judge really has a lot of power in just deciding a discovery issue that might ultimately decide the bigger issue. I'm sorry, JR, I interrupted you. Go for it.
I was just going to say that the bankruptcy court has a significant amount of authority. So yeah, but at the end of the day, Drew, we know they're going to be opposed. We know they are. The motions and the appearances are going to start flowing in over the next week. And so those briefs and motions are going to be interesting to read. And I'm sure we will be dissecting them on Spaces nonstop. Where Richard and I talked extensively about this, both publicly and privately, about this notion of bankruptcy after Sorrento. There is a risk, though. There's a risk. I mean, they're in bankruptcy right now. Now, we do know that MMAT did not intentionally file bankruptcy. They, the current board got rid of George and then drove the company into the ground. We had been talking about this in the context of, could it be used as a strategy by a board to take a voluntary, move into bankruptcy voluntarily under a Chapter 11? But there is still a risk. It's not a guarantee, because the judge could say, no, we're not going down this path. And, you're in bankruptcy, we're reorging and we're done. Or, we see how this is going to play out, where the judge agrees, but now you're going to have all these opposition motions come in and this is going to be a battle. So this is going to be, number one, it's interesting because we're all involved. But number two, from a legal standpoint, it's going to be fascinating to see how this plays out. And this is the type of case where Sorrento Therapeutics and now MMAT will be talked about, years after they've settled and everything is worked its way through the system. So,
and I think in the most recent filings, there was kind of like two separate avenues, and I do this a lot of times also. There was the subpoenas that were issued. I think they're out for service. They'll be served at some point in time. I noticed there was no date. It was a TBD. So I think they figure that the two things are going to cross, but they had subpoenas that are going to be served. And separate and apart from that, because the bankruptcy rules require it before, there's no adversary in bankruptcy. If like a complaint against someone, that would be an adversarial proceeding within a bankruptcy. There's none of that yet. So to proceed with discovery, you have to make a motion. So that's why they filed an ex parte motion, which means in essence they're doing it on shorter notice than normally would be required. And they're trying to get the permission of the court to permit them to conduct the deposition of these various, I think there were nine different deponents that were basically the person who's responsible for the record keeping at each particular company. So they're asking for permission, and they're also asking the documents to be produced there too. So it's a double barrel. And the way I equate it, it's kind of like what that pre-litigation discovery in New York was, where before, if you didn't really know who the defendant was, just to figure out who the defendant was and who might have specific liability, even though there was no case filed yet, you had the right to obtain pre-litigation discovery. I kind of see this as kind of in the same area. I think it's very subjective in terms of what the judge's discretion here. I think, and I don't know the judge. I don't know the bankruptcy judge, but I think there's enough discretion. They certainly can order, the production of whatever they want. And if they order it, then there has to be compliance. If there's no compliance, then they have the right to hold the non-complier in contempt. And the way you would enforce contempt is you could issue a monetary fine, or you could actually haul somebody in jail if they are not compliant. I would think if you ever got to that point where you're talking about like contempt for someone not producing documents in the bankruptcy, that you're at the end of the case anyway, because that means that there's something they really don't want to produce and they're kind of dead in the water. But that's kind of the way the sequence goes. I'm sorry, go ahead.
I kind of want to push back a little bit respectfully on what JR said there.
Sure, go for it.
So in a bankruptcy proceeding, correct me if I'm wrong, but the judge has a duty to the creditors to ensure a fair and equitable distribution of the assets while also overseeing the process to maximize creditor recovery as long as it's within the framework of bankruptcy laws.
I would say the only modification I would say is that yes, but they would probably do it and rely upon the trustee to carry that out, the function.
Yes, and the trustee has broader subpoena powers under the bankruptcy code to allow them to compel the production of documents and testimony from a wider range of parties than compared to a more limited subpoena authority in a typical federal court case.
Yes.
So if the trustee has reasonable grounds to believe that a party may have scammed the bankrupted entity and that a significant recovery is possible, the trustee, as we are learning, has the authority to issue these subpoenas. So there's nothing out of bounds about what they did. Now,
no, I agree. You're absolutely right. What I'm saying is if the judge has a basis in law to deny those subpoenas, the judge can. I'm not suggesting it's going to happen. I'm not suggesting it's going to happen.
While the judge has that duty to make sure that the process proceeds in a way to maximize recovery for, the estate now, that duty, as JR is just saying, that duty has to kind of be balanced with ensuring a level of fairness, due process, and adherence to ethical standards and the bankruptcy code. But I don't see anything that's out of bounds. I read, I didn't read all of them, but I read a number of the subpoenas for production when they live on a space last night as they were becoming available. Because, we saw the first one pop when Polakaris made his announcement, but then we saw the other ones subsequently come down the line, and they were becoming available literally while I was hosting the space. And obviously, and JR alluded to this yesterday, obviously with the SROs involved, with FINRA and the DTCC and the NASDAQ, you're going to see, they're going to push back under their regulatory immunity 100%.
Yeah.
But in fact, what I find to be really exciting about all of this is that there's so many parties involved in these subpoenas, and specifically with Anson funds, all you really need is one to give you the data to demonstrate something that could demonstrate a broader problem. And again, because the threshold in the bankruptcy code is what it is, I think it would allow the trustee a lot more leeway to then turn around and forcibly compel production to those parties that may be able to weasel out of it.
Well, I was going to say three things kind of, and the way I would frame it is if an attorney,
so
no, just play one on TV. If an attorney, gets a subpoena issued like me, that's fine. If the trustee, who's an agent of the court, it gets a subpoena issued by the court, in essence, it's the court that's making the request. So if there's a dispute about non-compliance, you're basically going against the court's agent, and you're much less likely to win that argument than you would against me, like a dumb lawyer who asks for something and it's a dispute because there's a problem with it.
But JR alluded to it, and what JR said was that it's the trustee's duty to carry out those obligations for the judge. And in my opinion, with what we saw yesterday, let's back up a little bit. So who selects the trustee? Like the trustee isn't someone that is, brought on by a party that would lead them to show favoritism. The trustee is supposed to be a neutral party here. The trustee in this case must have seen enough to say, okay, this investigation needs to proceed to ensure that the maximum amount of recovery is being the maximum amount is being recovered for the debtors here. So on the other side of the coin, I'm sure, because this was also announced somewhere along the line by someone, the legal team that has been brought in to assist the trustee in the course of their investigation has been fully funded. And we're talking about $11 million earmarked to go to this legal team. And that is completely, that amount is independent of the estate of MMAT. So this is, a third party bringing the money to the table saying, I'm willing to spend this money. Meanwhile, the trustee is seeing enough evidence to say, okay, like, this is justified. So to me, the fact that this even came out, I think is a real positive indicator, a real positive reinforcement that we're on the right track here. And not for nothing, not that it needs to be stated, but you guys alluded to this, George Palikaris was ousted here and quite frankly demonized and vilified, and in my opinion, wrongfully. Of course, if anyone is found to have committed wrongdoing, they should be held responsible for that, and I believe that 100%. But the fact of the matter is that I'm sure that the trustee went into this thing with a degree of skepticism, and still, like, they were shown enough. Trustee Lovato was shown enough to say, okay, this should proceed.
Yeah.
So
I guess what I would say is I'm going to have to see the response. There's going to be an objection. There might be a protective order motion. I'm sure somebody will come up with a creative argument. They might argue about the scope, the timing, the breadth, whatever.
Yeah, but you only need one.
Yeah, no, I know. I understand. But I'm cautious, so I want to see how it plays out. I want to make sure that, there's some disclosure. The other thing is, is it going to be a public disclosure, or is it going to be subject to some kind of protective order where whatever is produced is not disclosed beyond the particular case?
So,
because sometimes courts will order disclosures, but keep them protected until they have to be disclosed either during a trial or after the case.
Yeah, he said something happened. Yeah, here's a question, Richard. This is something I think we need to talk about. I'm wondering, now that I'm kind of thinking about this outside of the box, do you think MMTLP shareholders have some type of standing in this bankruptcy?
Yes.
In this particular case?
I do.
Yeah, I do too.
I mean, the document request says it, right?
Yeah. So let's have a deeper conversation about that, but hold off. We can talk about that another time. Drew, I want to go back to something you said, because I think you struck on some good points that we were kind of talking about yesterday in all the various spaces. And that's, the trustee saw something. The trustee has something to make them believe that there is something there to obviously issue nine subpoenas and, requests for information. But I'm wondering, and you made a comment, I didn't know this, about $11 million being put up. So if the trustee has seen it, that means the creditors have seen it. If the creditors are pushing the trustee to move forward, they're going to push hard because they want their money back. It's that simple.
That's what I heard. I heard, I heard that this was that Wes Christian being brought in as part of the team. I think it might have even been in the announcement that George made that Wes Christian was fully funded by an independent party, not by the estate. So
that was new to me. So
I haven't seen that either. So that's great, because that's you can't do it otherwise. You that's an element. You need funding for legal, or otherwise you can't do it. One thing I was going to say is, and it's interesting about Anson funds. So there was litigation in Canada involving Anson Fund and Hindenburg. And the issue that arose was that they were coordinating, that basically the funds and the shorts were coordinating. They'd write the reports and they would kind of work back and forth. They would get, they'd get monetary gain working together. Hindenburg basically shut its operation down right after that came out in the proceeding. So to me, it's kind of already been established that beyond just MMTLP, that Anson Fund has a lot of explaining to do, Lucy, I believe.
Well,
Who's Lucy?
I did some looking into that a while back, and Hindenburg. So Hindenburg is one of these investigative journalism type of deals, and they claimed that they were editorially independent, but in fact, the allegation is that they colluded with Anson to produce bearish reports that were targeting companies, and Anson was kind of directing this content and its timing to maximize the stock price drops for short selling profits. That's a serious allegation, and and a lot of people believe that there was a report. I forget. They had some group report. Hindenburg had some group report. I don't remember what the name of it was, and that actually led to its closure, with potential legal consequences looming for waiting in the wings for both parties. Now, the Hindenburg, the Anson thing is interesting, but at the same time, you also have TradeStation that made admissions to their clients that they don't have the shares.
Right.
So that alone, like all you need is one. And that alone is, in my opinion, should be more than enough for a judge to say, okay, you didn't have the MMTLP shares. Were you fully delivered on MMAT shares? What was going on there? Was that ever corrected? I think all of this is going to be real interesting as it relates not only to Anson, but also to TradeStation with respect to this bankruptcy thing.
Pun intended, it's in the judge's court.
Correct.
And, again, if the judge pulls the trigger, then this case is they're in deep trouble. All it requires is one document, one party, it doesn't take a lot for that thing to unwind. Just need a cooperative judge, and that, we'll have to see how that plays out, hoping for the best. Hopefully the trustee, by making the application, you kind of think that the trustee would know how the judge kind of feels about that stuff. And if the trustee thought the judge wasn't going to be receptive, they wouldn't file it. Kind of, that's how I would expect. So I'm optimistic that the motions be granted, and that, there'll be a fight. Of course, there'll be a fight and appeals or whatever. But if the judge grants the request to produce documents, eventually they'll either have to produce documents or settle, one or the other.
Well, George Polakaris put out a post earlier today. I don't know if you saw it, but he states that the Citadel ex parte motion was granted ex parte, and the judge signed off on that order. Actually, 3 of 9, one for the DTCC as well, and one for TD Ameritrade. So these are all orders granting the ex parte motion for orders requiring the custodians of records for these entities to appear for examination. So
did they have a date certain, or was a date to be agreed by the parties?
I think it was supposed to be within 14 days or otherwise agreed.
Okay.
I think. Yeah.
Okay. Yeah, that's great. I still would expect they probably will try to block before the time of the depositions, but an order is an order. So, that's as of now, they have to comply. And if they don't comply, they're in violation of a court order, and that's enforceable, and ultimately it's enforceable. If somebody doesn't comply, ultimately it's a judgment. That's the kind of, if you continue down the road, ultimately. Now there's no proceeding pending currently against any of those 9, but the kind of the suggestion is if the documents suggest that they will be defendants in an adversarial proceeding. And again, what adversarial proceeding is, it's like a lawsuit within a bankruptcy.
You know what the funny thing about this is? That to me, this it should only turn into an adversarial proceeding if one party has something to hide from the court. Otherwise, it should be, yeah, here you go. We didn't do anything wrong. We're not responsible for any injury, financial or otherwise, to any of the creditors or debtors here. Like, what do you want? Here's the data. But I guarantee you that's not how it's going to go.
Yeah, and obviously we know that up to this day that it's not fair for retail, right? In terms of disputes, we've certainly not got the benefit of the doubt or the benefit of anything. So, again, you're relying upon judges to be, stand out and do their job when it's appropriate. Here's an absolutely appropriate. It's not even, shouldn't be like it's a 5-minute. The fact that they ruled so quickly on the ex parte might be a reflection that the judge understands. The judge gets it. And that's why they ruled so quickly on the ex parte applications for the depositions of the custodian of records. But I agree with you. They should take responsibility for their actions. Why torture people, year after year, especially the history of people in MMTLP, the number of people that had health concerns, all the stress, and to kind of continue to pretend like they're not responsible is disgusting. I mean, there's no other way of saying it.
The question that has rang through my brain for the last 2 years, since congressional efforts have really ramped up and we've seen all kinds of legal efforts, yours, countless others. The question that has rang through my head multiple times is, why would you go to the expense, energy, and expenditure of resources and manpower to fight this if the data that is being requested would completely exonerate you of any wrongdoing? Why would you do that? I would just hand it over and say, leave me alone, have a nice day. But instead, in case after case, whether it's brokers, whether it's the regulators involved, they are going to the expense to fight these basic calls for basic transparency.
Yeah, you're right. I mean, J&R and I were talking about it when I was going through my stuff. There were like 3 law firms. They spent easily, I was guesstimating like $750,000 in legal fees just to, as opposed to just doing what was right. And again, if you got nothing to hide, then what, just out of principle, there's no reason to punish people and torture people out of principle. If there's nothing that's wrong, there's nothing that's wrong. Just come clean. But, but I agree. Unfortunately, they have, that's one of the issues. They have deep pockets and they're able to do that. And to, for most retail, they're not able to raise the money and to spend the legal fees. That's kind of the issue. That's why it's so beneficial. And when you mention it, that somebody's backing the proceeding, that is hugely important. That's when in our GTI thing, we also had somebody who's paying for the legal fees. Without that, we wouldn't have been able to advance it and be able to get a receiver and move forward on that also. So besides that and the ongoing proceedings and the subpoenas, and we'll see where that goes. And obviously we'll talk about that stuff as the responses and hopefully documents come out. Are you aware of any other litigation or legal proceedings that you think have any chance of being productive in working towards a resolution?
No.
Okay. Okay.
And again, like,
I'm sorry, I missed that. I'm trying to remember the questions that I'm seeing so we can get to them. What did you say? What did you say?
I basically asked him if he's aware of any other legal stuff that has any chance of succeeding. And the answer is no.
I cheered on Rosa. I cheered you on. I cheered on, Scott Trout when he started with his stuff. But wanting someone to win and then putting on your thinking cap and saying like, okay, how do I keep my expectations tempered, number one, and number two, what is the most logical outcome that is going to result from these case filings? When you're looking at something like the Federal Arbitration Act that is codified into federal law, judge is not going to go against that unless you can demonstrate like a severe prejudice or a severe violation of your rights that has occurred as a result of sending you to arbitration. A judge will not override that because you think something happened. You have to show it. And when you're talking about the Federal Arbitration Act, that applies to your brokers. And when you're talking about immunity for SROs, also codified into federal law, this is an insurmountable mountain to climb. However, the issuer is not beholden to those limitations in a lot of instances, one of them being via a bankruptcy proceeding. Now, I would have never wished this on metamaterials, but the fact of the matter is that this happened. I think that metamaterial shareholders, I think George is a very clever guy, and I don't think George is done. And I don't know how or in what form or fashion, but I don't think George is done with his metamaterials dream. And I also think that NextBridge Hydrocarbons is also standing there on the front lines, probably with bated breath, as it relates to the outcome of these subpoenas that were filed yesterday. So in terms of ramifications and potential implications to shareholders, both for metamaterials and MMTLP alike, I don't see any legal case to this point that had the weight or gravity of what we're seeing out of the bankruptcy court in the state of Nevada right now.
Okay. Hey, JR, you were looking for questions. Do you have any questions you wanted to address?
Yeah, there's a couple. I got three questions regarding, why wasn't Fidelity part of the 9 institutions that received the subpoenas and requests for documentations and questions answered? The short answer is number one, we don't know. So anything we say is merely speculation. I think personally, though, it's not why didn't other brokers get the requests. It's specifically why TradeStation did. And we all know that TradeStation was unique in this situation because they fessed up to not being able to provide the shares to shareholders. So it's not a matter of why didn't anybody else get them. It's, why the emphasis was on TradeStation, and that's why. And going back to what Drew said, 20 minutes ago, it's just one domino. They just need one domino, because if one domino falls, the rest of them are going to have to fall, because then they're all going to be guilty. So,
and worth mentioning is also the TD Ameritrade was included. I'm pretty sure TD Ameritrade was included. Were they not? I'm pretty sure they were.
Yeah, I think they were.
Yeah.
So that's got to trigger something in your brain. Okay, if they went after TradeStation because they had something on TradeStation, that's got to logically make you think, okay, they must have something on TD Ameritrade. I have no doubt in my mind that somebody sat with all of these brokerages in front of them and said, okay, this is what we have here, this is what we have there, this is what we have here. What are the best shots that we can take based on what we have in front of us right now? And I think, G-Boy, wouldn't you know, TradeStation and TD Ameritrade won the pony.
Yeah, I was going to say the other, and something that occurred to me.
We're giving away ponies? Fuck.
Something that occurs to me, if you're going to send out a bunch of subpoenas and you don't know how they're going to be received and responded to, that you might send them out in kind of tranches and see how the first group are responded to, and then maybe adjust accordingly the next group to kind of take into account whatever potential issues are raised. So it could be a strategic reason. Could be any reason. I don't know. Maybe Drew knows. I don't know.
No,
But
I don't.
you know, whatever they decided, and we'll see how it plays out. Again, we're going to see it play out in real time, so we'll see it, and we'll see if we're able to get the documents.
I worked for a company once upon a time. I worked for a company that went through bankruptcy, and it was a really long time before any distributions were made. But I stayed on top of this case very religiously because they owed me a few bucks, and I wanted to try to recover as best I could from it. And you pick up these things, you pick up the procedural steps involved in a bankruptcy court, and when you compare it to the limited scope of what one can do as a plaintiff in a federal court, which is where all of these other actions are, it is a very stark difference. And that's why I say what I say about, and that's why I'm so quick with the answer of no, I don't see any other legal pathway unless NextBridge really throws their hat in the race here, because I think McCabe has some legal cards he can play too.
Yeah, I think I agree with you. For individual, it's really stacked against you, and the immunity is really the killer, in my opinion. That I think SROs should, I've said it a billion times, but I think SROs should be stripped of their immunity. And if they were stripped of their immunity, I think that would be a solution to all these cases, because they'd have to produce documents early on, and it would basically kind of nip these things in the bud. As of now, they're.
And it's about force. When a company is going into a legal proceeding, all of the shareholders of that company are not considered as plaintiff, but the courts know that the shareholders have a direct interest here. There's a lot more at stake than maybe just a singular investor filing a claim that may seem fringe on the surface.
Right.
So I think all of that is worth considering as well.
Okay, appreciate it. Anything else you want to add about the current status of MMTLP?
When I say this on every single broadcast that I go on, so I'm also going to say it here. We're not going anywhere until this gets resolved. And that word, the root word, resolve, that is something there is no shortage of in this community of people. It cannot be overstated the amazing resolve and will of this group of shareholders. And it's cool. What I really appreciate here is that everybody now in the last few months is seemingly has found their groove and is playing into their strengths. And is okay, like this is my lane, and that's the lane that you're in. And if we all push as hard as we can in our own respective lanes, eventually someone is going to get to the finish line. And this movement has kind of grown and evolved and found its way to that point. So, if anything, the only thing that I would say, especially to the shareholders that are listening, is we've all got to be doing everything in our power. And as long as we're all doing everything in our power, I have no doubt that we will eventually see a favorable outcome. And I know JR had two more questions that he wanted to.
Yeah, I can't find the other question I was looking for because people are.
I found it. I did find it before, and I responded. But the question was from Destin, I believe. And
yeah. No, there was. I saw that you answered that. There was another one that was talking about. It said MMTLP or MMAT, and they asked if it should be and not or. That's the one I was looking for because I thought it was a legitimate question. So I'll go back and sift through the live chat after the show's over.
Is it a question about the language in the?
I think it was a question about the language in the documents. Yeah.
Yes, it wasn't. If I recall, it didn't exclude. It didn't say one or the other. It's still both. Even if it was and or, it's both. It's still both.
the or pertains to other QSIPs or legend identifiers that pertain to Meta or MMTLP. So it's, that word or, I think that's just playing on the semantics of the thing. I think the judge understands, and I think all parties involved understand that it involves both. But going back to Justin's question, I do want to state it anyway, because for the other viewers involved, it may be applicable here. And the question was something along the lines of, if you feel like you're having trouble with your congressional representative or getting through to a staffer, what advice would you give? The fact of the matter is that I've had a lot of success with the approach of bringing up 74 congressional members signed an open letter inquiring about an issue that affects me. You are my representative. All I'm asking is for a conversation with your office so I can provide some context, address recent developments, and perhaps examine ways that your office may be able to help. And that demonstrates, to me, it demonstrates, number one, respect for their time and understanding of, that I don't know everything and I'm open to hearing how you might be able to help. And number three, I want to save you some time by putting all of this stuff into context for you. So that's been my approach. I have a letter that I've been distributing privately that is uniform for anyone. If they want to reach out via DM, my DMs are open. I'm more than happy to send you this letter. And if needed, I'll even look up the proper staff personnel of your representative to help make sure that you're sending your emails to the right person and not just some website generic, boilerplate form that a lot of shareholders have resorted to reaching out to because they didn't know who the right person was. So my DMs are open for that purpose, and I'm always ready to go.
Thanks. Thanks. I appreciate you giving us your point of view and supplying us with a lot of information that we didn't have before. It helps everybody. It really does. It helps everybody get a better picture. It helps also hearing it over and over again. It helps. It's a complicated fact pattern. It helps hearing it, makes us remember it better. And so it's much appreciated. And your efforts have been much appreciated. And, we all hope that we get to a speedy resolution, if that, 2.5 years later. JR,
I want to thank the two of you as well for your efforts and just your presence and your voice in the community. I know has been a big consoling factor, and it's helped to temper a lot of expectations as each one of these legal claims were brought forward. You helped people stay grounded and stay tempered, and that's so important because it's one thing. Hope taken too far can be detrimental to someone's mental well-being. And, I'm incredibly grateful that, we have the two of you to help keep us, help keep everybody grounded around here. So I definitely want to thank the both of you as well. And I'm just grateful if I could contribute in some meaningful way to any of this. So thank you.
Well, thank you. And it's appreciated. We appreciate your presence.
Yes, thank you. I personally thank you for that, Drew. I tend to really try to work far harder than Richard, and I think that shows.
Yeah, I agree.
I agree. We do have one more question I want to get to, and it's Brett. His question is: can the subpoenaed entities play the redaction game in furnishing discovery to the bankruptcy court or trustee? I think what he's asking is can they provide the information, but it all be redacted or not made public?
Only if it's personally identifying information that could jeopardize or be of detriment to the security of one of the parties involved or their business practices.
Yeah, I would say slightly different. Only if the judge agrees.
Right. I want to differentiate here because this is, and again, me kind of cross-pollinating in these other communities. This is an issue in the Bed Bath and Beyond bankruptcy, and I think people don't seem to understand that there's a case against a financial institution that's being brought by the bankruptcy estate in Bed Bath & Beyond. But the case isn't in bankruptcy court. It's in the Southern District of New York.
Yeah.
And there's a significant portion of that complaint that has been redacted. Hell, they didn't even publish the amicus brief. That's all under seal. So it's a different situation in that particular case, and it's an entirely different court. So going back to what Richard said, it's going to be up to the judge, or it might very well be related to personal identifiable information. But I will note that was a source of contention in the Sorrento case, and they found a way around it.
Yeah.
So,
yeah. Is that the last question?
Yeah, I think that's the last. Let me just get down
because I said I'm going to do a quick GTII. The negotiations are still ongoing between the target and the receiver. They're trying to work out the issues with control involving other shareholders, and that's where they stand. And hopefully they will have the final audited financials by the end of March. We'll keep you apprised on that. That's a quickie because I promised to do that. Again, Drew, I wanted to thank you again for the time and all your efforts and your future efforts. And I know eventually one day it will all pay off. We will get to the end. I'm still confident. But I appreciate all your energy, and everybody seems to have a new kind of peak of energy. So it's great. And again, I appreciate all your efforts, and thank you for coming out tonight.
Wherever you guys come, for all MMTLP shareholders, wherever you come, wherever you go, may you all be delivered safely and in God's hands. Thanks, guys.
And everybody be well, take care, and we'll see you soon. And good night.
Rich.
Good night.
Thanks.